Coming up, the bottom line is that Justice Gorsuch gets what's going on here. Welcome back to Political Spirits. I'm your host, Franklin Rye. We still stand for the proposition that the left and the right should have a few drinks and talk. Compromise is not a requirement. If those discussions result in us changing or even abandoning our positions, that's fine. If they don't, that's fine too. We just need to talk to each other. In that way, we can unify through speech. And if the discussion becomes a bit heated at the end of the night, we should still be able to split up the bar tab and be on our way. So what are we going to talk about this week? Last week, I talked about what is the truth. I talked about the fact that the internet is basically built to emphasize definitive statements and certainty, even when things are far from definitive and far from certain. You've no doubt witnessed the fact that the mainstream media outlets have become so committed to the Biden camp, to ensuring that he's inaugurated as president, to ensuring that President Trump doesn't get any traction with his various election challenges in the courts and in state legislative hearings into the issue, that they've nearly embargoed coverage of the specifics of those challenges. To the extent that they do cover them, they only do so when a court renders a decision adverse to the Trump campaign or to the other interest groups filing lawsuits which support President Trump's contentions. To the extent they do cover President Trump's arguments about the election, they almost always try to refer to them as a conspiracy theory. And you've probably witnessed the fact that there's a tendency from many commentators on the right to be overly positive. And I say that recognizing that I'm on the right. But I'm trying to give you the straight truth, straight up, not trying to embellish, not trying to exaggerate. I witnessed that tendency to be overly positive last night when I watched the YouTube video of a commentator making predictions based on the fact that a trial judge in Pennsylvania had issued an injunction against further certifications of the Pennsylvania election based on the conclusion that the plaintiffs were likely to succeed on the merits of their claim that the Pennsylvania law expanding absentee voting was unconstitutional because it needed to be accomplished by constitutional amendment, but instead was simply passed as a new statute. That commentator concluded that that court decision would create a domino effect, with the remaining states subjected to challenges by the Trump campaign falling promptly in line with the arguments of the campaign based on that Pennsylvania decision. The moment I heard that, I concluded it was absurdly overly positive, because I fully expected the Pennsylvania Supreme Court to overturn the judge's decision. Incidentally, the Pennsylvania Supreme Court is comprised of 6 Democrat justices and 1 Republican justice. Sure enough, shortly after I watched that YouTube video, the Pennsylvania Supreme Court rendered its decision. The justices overturned the trial court and dismissed the case with prejudice. They ruled that the plaintiffs were too late, that under the doctrine of laches they had unreasonably delayed in filing their claim. In other words, the court concluded that they should have filed before the election occurred so that a less disruptive remedy could have been implemented. By the way, the plaintiffs were not the Trump campaign. Interestingly, the Supreme Court left open the possibility that a suit could be filed to impact future elections, just not this one. What does that tell you? It tells me that the plaintiff's argument was likely right, that the statute that passed purporting to expand absentee voting under Pennsylvania law was in fact illegal, unconstitutional under the Pennsylvania Constitution. But they should have filed a suit to have it overturned before the election. When they did file suit, I read the complaint and thought it was spot on. I wondered why the Trump campaign hadn't filed it itself. Maybe it's because they saw the laches problem as well. The case may end up in the U.S. Supreme Court, but I have to admit that it's a stretch to think that SCOTUS would overturn the Pennsylvania Supreme Court on such a state law question. We'll have to see what federal questions the plaintiffs assert if they try to move into the federal court system with the claim. I've had some people tell me recently that they've met a lot of Republicans who are frustrated and questioning the wisdom of President Trump's election legal challenges. My response is always the same. Al Gore took 37 days. We should give our president at least that much time to litigate the issues. Having said that, there are a lot of issues and people need sources to go to for information, especially given that the mainstream media is hopelessly biased to the point of essentially being Biden campaign propagandists. And within the new media on the right, there are quite a few sources that are positive to the point of being completely unreliable. So other than political spirits, where do you go? Well, I would like to mention the one article I read recently that did the best job of synopsizing the main reasons for believing that massive voter fraud and election fraud occurred. That article is entitled Reasons Why the 2020 Presidential Election is Deeply Puzzling. It appeared in The Spectator on November 27 and was written by pollster Patrick Basham. It's not that long, but it's packed with details, and I highly recommend you read it. Among other things, Basham details how Biden experienced a huge spike in support from the urban core, but only the urban core of specific cities in specific swing states he needed to defeat President Trump. Strangely, that spike in support wasn't experienced by the Biden campaign in other urban cores in other cities around the country. Here's a few of my favorites from that article. Quote, "We are told that Biden won more votes nationally than any presidential candidate in history, but he won a record low of 17% of counties. He only won 524 counties, as opposed to 873 counties Obama won in 2008. Yet Biden somehow outdid Obama in total votes." Close quote. And there's this, quote, "Victorious presidential candidates, especially challengers, usually have down-ballot coattails. Biden did not. The Republicans held the Senate and enjoyed a red wave in the House, where they gained a large number of seats while winning all 27 toss-up contests. Trump's party did not lose a single state legislature and actually made gains at the state level." Close quote. He then lists some of the election counting anomalies we've heard about. My favorite, not because I like it, but rather because it reveals just how bizarre and unbelievable, and I really do mean literally unbelievable, the count from this election has been. Quote, "In Georgia, Biden overtook Trump with 89% of the votes counted. For the next 53 batches of votes counted, Biden led Trump by the same exact 50.05 to 49.95% margin in every single batch. It is particularly perplexing that all statistical anomalies and tabulation abnormalities were in Biden's favor." Close quote. Perplexing indeed. Next topic. SCOTUS COVID condo boards, pickup trucks, and Governor Cuomo. Let's talk about something that illustrates what I've said for some time about the left, about the Democrat Party as it's increasingly moved further and further to the left, and that is that we've reached the point where the Democrat model of good governance seems to be an out-of-control condo board. You know, the stereotypical condo commanders sitting around trying to come up with new restrictions, new ways to assert their power, and to the extent they even bother to think about whether they're going too far, they ask themselves whether what they want to prohibit is something they would want to do, rather than whether somebody else might want to do it. You know what I'm talking about, the kind of condo board member that says to his spouse, "I don't need a pickup, you don't need a pickup, let's ban pickups." As we've lived through the succession of primarily Democrat mayors in blue cities and Democrat governors in blue states imposing draconian lockdown measures purportedly to fight COVID, but often supported not by actual science in the form of actual studies, but rather by quasi-scientific speculation, I've grown more and more frustrated wondering when these power-hungry mini-dictators would be called to task by the courts. You know the kind of thing I'm talking about. Just look to the best example of such governmental overreach in the blue states. Look to Governor, or rather Übergruppenführer Gretchen Whitmer in Michigan and her ludicrous prohibition of boats with motors while allowing those without them. I've been a boater for much of my adult life, and I've recognized the negatives associated with the power necessary to lift a boat up on top of the surface of the water and push it along at high speed. The fuel consumption that sometimes made me feel like I was at the helm of a supertanker instead of a fishing boat. Back in the day, the outboard howl that made quiet conversation about as likely as calm, unbiased questions from the media at a Trump press conference these days. And repair costs high enough to make you think you're driving a classic British roadster rather than a speedy center console. But what I never thought about is that somehow the presence of a couple of outboard motors could turn that center console into a mechanism for transmitting a virus, but that for some reason it was immune from transmission in a rowboat. Of course, I suppose that's explained by the fact that I've never possessed the magical scientific insights of Governor Whitmer. So was it Governor Whitmer who was recently called to task for her COVID restriction overreach? No, it's the gubernatorial darling of the mainstream media who was finally smacked down by the courts, or rather, the court, the top of the line, the U.S. Supreme Court. And it's not just a reminder of how the Democrat Party is moving towards becoming an out-of-control condo board. It's also a reminder of just how important it was for President Donald Trump to nominate Amy Coney Barrett to the Supreme Court and have that nomination confirmed. On November 25, the Supreme Court rendered a decision in the case of Roman Catholic Diocese of Brooklyn, New York, versus Andrew M. Cuomo, Governor of New York. The case was filed by the referenced Roman Catholic Diocese and also a group of Orthodox Jewish synagogues. So what were they challenging? Governor Andrew Cuomo's dictates that no more than 10 people may attend a religious service if the location is within a red zone for coronavirus infections, or 25 people if the location is within an orange zone for coronavirus infections. The numbers don't increase from the 10 and 25 person maximums if the church or synagogue or other house of worship is huge. Imagine, for example, the largest Catholic church in New York City with a 10-person or 25-person attendance limit if it's in a red or orange zone. And the Catholic churches run by the diocese which filed this suit were big enough to hold up to 1,000 parishioners. When I heard about those limits and when I watched the belligerent way in which Governor Cuomo referenced Orthodox Jewish institutions and residents of New York regarding this issue, I was stunned. And frankly, I was hopeful that the restrictions would be struck down and right quick. It's unfortunate it had to go all the way to the Supreme Court, but the fact that it did helps ensure that there will be a broader understanding that there are limits on how far government can push infringements of the rights of its citizens. So what exactly did the Supreme Court decide? Well, before the court was the request for an injunction to prevent enforcement of the limitations on attendance on the churches and synagogues that had filed suit while the case winds its way through the courts. The conclusion of the court? Yes, New York would be enjoined from enforcing the restrictions against the plaintiffs. The analysis was simple, direct, and exactly what I'd hoped for. The court concluded in a 5-4 decision that the order issued by Governor Cuomo restricting religious services to 10 persons when in red zones and 25 persons when in orange zones was unconstitutional because it violated the free exercise of religion clause of the First Amendment. In brief, the analysis was that the order treated religious services less favorably than non-religious services because it designated services including liquor stores and bicycle shops as essential, and those were not subjected to attendance limits, while religious services were considered non-essential. In an orange zone, even various locations and businesses providing non-essential services were not subject to attendance caps, even though religious institutions would still be subject to a limit of 25 worshipers, no matter how large the church or synagogue. As a result, the court concluded that the state was not treating religious institutions equally to secular institutions. It was not treating them neutrally. Therefore, the constitutional standard that applied was strict scrutiny, and the state would have to demonstrate that Governor Cuomo's executive decree was narrowly tailored to fulfill a compelling government interest. On those points, the state failed miserably. It never showed any evidence of a COVID-19 outbreak in any of the churches or synagogues of the plaintiffs after the reopening. Likewise, it never showed any failure of any of the churches or synagogues to follow the other health protocols mandated by the state. Then, addressing the question of narrowly tailoring the restrictions, the failure of the state was obvious. They could have, for example, imposed restrictions based on a significant percentage of the church capacity or a fixed number, whichever is higher. But instead, they chose to phrase it as a percentage or a fixed number, whichever is lower. As a result, the restriction to 10 or 25 people is incredibly low for a facility with any significant size. And as noted, the Catholic churches in question were as large as 1,000 seats, and the synagogues in question were as large as 400 seats. With that background, it isn't even slightly surprising that the court concluded that the state had not narrowly tailored its restriction. Having said that, this was not a decision on the merits. It was a decision as to whether to issue the preliminary injunction against enforcing the rule while the case winds its way through the federal courts. But given the statements made in the opinion and in the concurring opinions, it seems highly unlikely that Governor Cuomo could ever successfully defend those restrictions if, in fact, he continues the fight. So what was my favorite part of the decision? I have to admit it was in one of the concurring opinions, the one by Justice Gorsuch. Quote, "Government is not free to disregard the First Amendment in times of crisis. At a minimum, that amendment prohibits government officials from treating religious exercises worse than comparable secular activities, unless they're pursuing a compelling interest in using the least restrictive means available." He then cites a couple of cases that are relevant, actually one case, and then says, "Yet recently, during the COVID pandemic, certain states seem to have ignored these long-settled principles. Today's case supplies just the latest example. New York's governor has asserted the power to assign different color codes to different parts of the state and govern each by executive decree." Close quote. Gorsuch goes further, quote, "At the same time, the governor has chosen to impose no capacity restrictions on certain businesses he considers, quote, essential," close quote. And it turns out the businesses the governor considers essential include hardware stores, acupuncturists, and liquor stores, bicycle repair shops, certain signage companies, accountants, lawyers, and insurance agents are all essential too. So, at least according to the governor, it may be unsafe to go to church, but it is always fine to go pick up another bottle of wine, shop for a new bike, or spend the afternoon exploring your distal points and meridians. Who knew public health would so perfectly align with secular convenience? Close quote. One of the things I like about those quotes is they make it crystal clear that when you're talking about the executive decrees in question, you're talking about the decisions of one man, the governor, and the governor alone. These are not the decisions of a legislative body. Now, that doesn't automatically make them wrong, of course, but it should cause particular concern when, as here, those dictates seem to ignore the traditional treatment of churches in America. In other words, we traditionally give them at least equal treatment with secular entities. Here, Governor Cuomo turned the tradition on its head and deliberately treated them worse than secular entities. Moreover, the quote includes a well-deserved dose of sarcasm. Quote, "Who knew public health would so perfectly align with secular convenience?" Close quote. The bottom line is that Justice Gorsuch gets what's going on here. He understands the problem is that Governor Cuomo and far too many people in government on the left don't think church is important, and they really don't care that others do. They don't think going to synagogue is important, and they really don't care that others do. The only way Justice Gorsuch could have been more clear in revealing that he knows what's really going on here is if he'd compared the Cuomo administration to an out-of-control condo board banning pickup trucks. But that wouldn't have been very judicial of him. If he ever leaves the court to become a podcaster, maybe we'll hear that from him, but I'm not betting that happens anytime soon. So your best bet to hear that kind of analogy is to listen in next week, as always, when I'll be back with another episode of Political Spirits, and tell your friends to do so as well. And like the podcast on Facebook at Political Spirits, and follow me and the podcast on Twitter at Franklin Rye. And remember, all episodes are now on YouTube as well, and the YouTube channel is named Political Spirits Network. If you're watching on YouTube, be sure to like and subscribe and hit the notification bell, and select all after you hit the bell. This is Franklin Rye. Thank you for listening.